Good evening, ladies and gentlemen. You're listening to the Hour of the Time. I'm William Cooper. Now, I want you to pay close attention because starting tonight, I'm going to be hitting you with some heavy-duty facts about the criminal, unconstitutional, unlawful, liars, hoaxers, defrauders known as the Internal Revenue Service. That includes the Bureau of Alcohol, Tobacco, and Firearms, by the way. And there appears to be some link with the Secret Service. Now, well, I'll explain a little bit of that later. Back in 1995, we published a front-page article in Veritas newspaper entitled BATF IRS Criminal Fraud. And we outlined just some of the things that we discovered when we investigated the origins of and the legality or criminality of the Internal Revenue Service and the Bureau of Alcohol, Tobacco, and Firearms. What we discovered was amazing. And not to mention that it sure made a lot of people in the Internal Revenue Service, the Department of the Treasury in Washington, D.C., very angry with me. Now, tonight I'm going to read you a letter that was sent out by Dan Metter, who's a very good researcher into the law and the income tax and a whole bunch of other things. And the subject of the letter is the article that I wrote and that we ran as the headline story in Veritas in 1995. And so tonight you'll get Dan Metter's comments on that story. And then beginning tomorrow night, I'm going to read you the entire story. Remember, what you're going to hear is just some of the results of the investigation. The story was written as a revelation of the compilation of the research of me and a man named Wayne Benson, who lives in Payson, Arizona. We pooled what we had learned over years of looking into these things, and the result was the story that I wrote and published as the lead article in Veritas in 1995. So here we go with the letter from Dan Metter. Please pay attention because Dan contributes more information as a prelude to reading the article so that you might understand it a little bit better. And he sent this out to all of his, the people who are in his research circle and who participate in research with him. Who and what is the IRS? Historical note, history and new evidence that it is a foreign agency. By Dan Metter, April 1st, 2000. Evan, you all know Evan, I've talked about him before, forwarded the following article by Bill Cooper, published in the September 1995 issue of Veritas newspaper. Since I'm suffering the fatigue of not getting home from Tulsa until the wee hours of the morning, and can't seem to get kick-started to do what I should be doing, I'm going to take the opportunity to provide context for the lengthy Cooper article and add information gleaned from research since. For those who haven't seen it, the Cooper article should be enlightening. Additionally, evidence revealed in my portion of this compiled article is going to floor many readers. However, before disclosing new evidence, I'm going to present something of a history. Now listen very carefully, ladies and gentlemen. Make sure that you follow this and take notes if you need to. Gail and I had just finished what we called the Monster Tax Index when someone sent the Cooper article via fax shortly after it was published in September 1995. Our index went through the Internal Revenue Code section by section, listing regulations as they appear in the parallel table of authorities and rules. Then we listed the regulation headings for the regulations. Because of our index, I was able to verify many of the references in the Cooper article without having to go to actual texts. And what I found was that many Cooper-Benson conclusions were verified by the index. Of particular importance, we found that there are no implementing regulations for 26 United States Code Section 7621 which authorizes the President to establish revenue districts. Consequently, there are no revenue districts in states of the Union. However, there was a significant gap in Cooper-Benson research. At that point, they hadn't found origins of the Bureau of Internal Revenue, Puerto Rico. Well, that's not true, folks. I had found definite origins for the Bureau of Internal Revenue, Puerto Rico, and I gave them plenty of opportunity to find that in the article. And I did, of course, not publish everything because it's a lengthy article to begin with, and if we published everything, it would have been a book. Continuing, and this is Dan Metter speaking. I documented it in late 1998, even though I knew where to look when I read the Downs versus Bidwell decision in 1997. The first civil governor of Puerto Rico established 5 bureaus in the Puerto Rico Department of Treasury on May 1st, 1900. The 5 bureaus were eventually to become the Bureau of Internal Revenue, Puerto Rico, predecessor to the Internal Revenue Service. The name change of BIR to IRS was in 1953 in advance of implementing the Internal Revenue Code of 1954, based on Reorganization Plan 26 of 1950 and Reorganization Plan 1 of 1952. Early Puerto Rico legislation, beginning with the gubernatorial and executive committee acts of May 1900, are published in Senate documents for the period. So it's just a matter of going through the publications to complete the merger history. Benson and Cooper located origins of the Bureau of Internal Revenue, Philippines, and the Philippines Special Fund in 1904 documents. The Philippines gained independence in 1946, leaving BIR Puerto Rico as the only Bureau of Internal Revenue that was legislatively created, and not by Congress at that. The first Puerto Rico legislature in 1901 legislatively enacted Executive Acts of May 1900, and we disclosed the existence of the Bureau of Internal Revenue Trust Fund, number 62, in our article of September 1995. In 1934, that was me just speaking. This is Dan Metter speaking again. In 1934, Congress stipulated that the various special funds maintained by the Department of the Treasury would be known as trusts. In effect, Philippines Trusts 1 and 2, and Puerto Rico Trust number 62, all 3 of which are still in the books in Title 31 of the United States Code. In his article, Cooper cites the Federal Register and the Internal Revenue Manual acknowledgement that Congress never created a Bureau of Internal Revenue. Someone else has since located a Supreme Court decision where justices of the Supreme Court affirm that Congress never created a Bureau of Internal Revenue or Internal Revenue Service. Consequently, the Internal Revenue Service has no lawful authority to enforce anything in the Union, as Congress is charged with responsibility for establishing any government, department, or agency that the Constitution itself does not establish. At the tail end of this article, we're going to share disclosures attorneys in Illinois and Idaho have secured that constitute astounding revelations that should give everyone cause to rethink strategy relating to the Internal Revenue Service. I will continue the account of the research effort that lays the factual foundation. In the historical account by the Commissioner of Internal Revenue, published in the Federal Register and the Internal Revenue Manual, the Commissioner alleges that Congress clearly intended to create a Bureau of Internal Revenue in 1862 legislation that established the office of the Commissioner of Internal Revenue. But reading the 1862 legislation reveals that there was no need for a Bureau of Internal Revenue or Internal Revenue Service. And indeed, this is me speaking now, Congress never created either one. It doesn't make any difference what Congress intended to do. It only makes a difference what Congress actually did or did not do. And in this instance, regardless of the Commissioner of Internal Revenue's assertions, Congress did not create any Bureau of Internal Revenue or any Internal Revenue Service. But reading the 1862 legislation reveals that there was no need for a Bureau of Internal Revenue or Internal Revenue Service. Congress established the offices of assessors and collectors, with one of each to be appointed for each revenue district. These offices were on the order of current U.S. attorneys' appointments. They were political patronage positions. The offices continued to exist until implementation of Reorganization Plan number 26 of 1950. In order to understand what happened, excuse me, folks, still fighting a little congestion here. In order to understand what happened via the reorganization plans behind the current Internal Revenue Code, we need to review what happened with respect to prohibition. In 1933, the 21st Amendment repealed the 18th. However, federal enforcement people continued to enforce state laws relating to alcohol to the point of the Constantine decision in December 1935. In the decision, the Supreme Court said that once the 18th Amendment was repealed, state and federal enforcement ceased to have concurrent jurisdiction for enforcement of alcohol-related laws, as the 18th Amendment contained the grant of authority. Once it was repealed, concurrent jurisdiction was repealed, and the United States government no longer had any jurisdiction within the territorial boundaries of the states pertaining to the enforcement of alcohol laws. Until summer 1935, the feds had operated on the Alcohol Administration Act of 1926. That was replaced by the Federal Alcohol Administration Act of 1935, enacted that summer, several months in advance of the Constantine decision. In the wake of the Constantine decision, a director was appointed, but the Federal Alcohol Administration wasn't established to administer the Alcohol Administration Act. Via Reorganization Plan number 3 of 1940, administration of the Federal Alcohol Administration Act was transferred to the Bureau of Internal Revenue, predecessor of the Internal Revenue Service. And as you learned before, that is an office of Puerto Rico. As the Cooper article suggests, Bureau of Internal Revenue, Puerto Rico, and our Bureau of Internal Revenue, Philippines, had already encroached into states of the Union via the China Trade Act legislation, which implemented maritime or customs laws relating to trade in opium, cocaine, and citric wines. That's opium, cocaine, and citric wines. The first drug-related law was passed in 1914. Then, with the 1918 amendment, the feds began to enforce drug laws in the several states. Now, this is why, ladies and gentlemen, and this is not Dan Metter, now this is me, William Cooper. This is why when you seek out through the Freedom of Information Act and are actually able to obtain your master file from the Internal Revenue Service, you will find there are codes in there that when you have the proper IRS manual to decode them, it says that you are being taxed because you are dealing in the importation of opium, cocaine, and or citric wines. Nobody could figure that out until we published the article. Back to Dan Metter. The timing was ideal. There was significant political mobilization responsible for the 18th Amendment and alcohol prohibition. so the feds took advantage of empathy for purging any kind of intoxicating substance. In his letter supporting the 1940 reorganization plan, Roosevelt said that the Bureau of Internal Revenue had been enforcing provisions of the Federal Alcohol Administration Act. Anyway, so the transfer of responsibility didn't effect significant change. Sometime before Cooper wrote his article, I read the 1992 New York versus United States decision. In the decision, the Supreme Court used the term cooperative federalism. My response was, what the hell is cooperative federalism? And as an aside here, folks, if you get into studying the law concerning the Internal Revenue Service, the Bureau of Alcohol, Tobacco, and Firearms, the Secret Service, and the way they do business and how they operate under color of law, you'll find all kinds of things that will make you have the same response. What the hell is that? Back to Dan Meador. The next time I saw published use of the term was in the title of an article in the 1992 edition of The Book of the States. In the meantime, I ran across the Federalism Executive Order Ronald Reagan put in place. The Reagan Order, which technically preserves constitutional integrity, is the one Bill Clinton kept trying to overhaul, but he is getting considerable resistance. This particular executive order is an executive policy statement. It doesn't meet standards of 3 United States Code, Section 301, and the Federal Register Act. It is simply the prevailing policy statement that informally shapes relations between state and federal government. Now we have 2 essential identifying terms. On the federal side, federalism, and on the state side, cooperative federalism. Now let's address the scheme of things through 2 constitutional questions. Have Article 1, Section 8, Clauses 5 and 6, and Article 1, Section 10, Paragraph 1 of the Constitution been repealed or amended? Has the Constitution been amended to effect prohibition against opium, cocaine, and other such substances? We'll follow those questions with 2 more. Do we have gold and silver coin as our national currency? Do we have national prohibition against drugs? In light of the first 2 questions, we can conclude that Congress has defaulted responsibility for providing a national currency of gold and silver coin, and our states of the Union are accommodating the fraud without a constitutional amendment. And in light of the second question, we can conclude that federal government is exercising a power which is not enumerated in the Constitution, and our respective state governments are accommodating the usurpation of power. Obviously, the Federal Reserve Act of 1913 was patently unconstitutional. At least it was if it applied to Union, but it might not be if it applied to United States government itself and territories and insular possessions of the United States. Likewise, the federal drug laws would be legitimate if they applied to the District of Columbia and insular possessions of the United States. It is here that Congress has plenary or near absolute power, and we can lengthen the list. The Federal Alcohol Administration Act is legitimate in Puerto Rico, but not in Oklahoma. Likewise, the Social Security Act of 1935 is legitimate in Puerto Rico, the Virgin Islands, etc., but not in Kansas. Where the latter is concerned, we see proper geographical application and definitions of state, United States, and citizen at 26 Code of Federal Regulations, Section 31.3121, small e-6. At the January 1937 General Conference of the Council of State Governments, delegates from a majority of our state legislatures endorsed the Declaration of Intergovernmental Dependence. This formalized what was already a working arrangement. States of the Union formally went on the federal dole system, and by setting up the infrastructure, provided a forum for general agreement among state governing bodies as to what federal encroachment they would accommodate. Now, as an aside here, folks, the federal government is a state. Each separate state of the Union is also a state, independent and sovereign, except where it's given power in the Constitution for the United States of America to the federal government. Now, since each state of the Union is a state, and since the federal government is a state, this kind of arrangement and agreement is prohibited by the Constitution, which clearly says the states of the Union will not enter into any treaty with any other state. A treaty is an agreement or a contract entered into by two or more states. These kinds of agreements, resulting in cooperative federalism, are in fact treaties which are forbidden by the Constitution, and therefore they are unlawful, unconstitutional, and in fact, when they encroach upon the rights of the citizens and of the sovereignty of each individual state, they are treasonous. Treasonous. Back to Dan Metter. Here are more relevant questions. Does the executive branch have legislative authority? Can the president unilaterally repeal law once it has been formally enacted by Congress? Via Reorganization Plan Number 3 of 1940, Roosevelt reassigned duties of the Federal Alcohol Administration to the Bureau of Internal Revenue, thereby abandoning the agency Congress established. Then, via Reorganization Plan Number 26 of 1950, Truman effectively terminated the offices of assessor and collector Congress established in 1862. In other words, after the Supreme Court determined that federal enforcement agencies had no authority to enforce state alcohol law in the several states, administration of the Federal Alcohol Administration Act was moved under authority of the Bureau of Internal Revenue, Puerto Rico, for administration in insular possessions of the United States. By law, the Bureau of Internal Revenue, Puerto Rico, could not be exercised in the Union, but since state governments were willing to accommodate federal encroachment in return for whatever financial incentives federal government provided, the fraud was and has generally been accommodated. The scheme worked well enough that in 1950, Truman followed the Roosevelt lead by authorizing Bureau of Internal Revenue, in effect, the Internal Revenue Service, administration of federal income tax law. But the geographical application remains the same, limited to the District of Columbia and insular possessions of the United States. Any encroachment into the territorial boundary of any of the several states of the Union is not only unconstitutional, it's unlawful, it is a fraud, it is treason. Through their gross income source research, Tupper Saucy, Thurston Bell, Larkin Rose, and various others have documented that the American people in general are liable for federal income tax, but are liable only on income from foreign sources and insular possessions of the United States. These conclusions reinforce and are consistent with my research and the research by Benson and Cooper. With enactment of the Internal Revenue Code of 1954 via Truman Executive Orders, the offices of Assessor and Collector of Internal Revenue were terminated, and administration of the Internal Revenue Code by appearance was turned over to the Internal Revenue Service, an agency of the Department of the Treasury, Puerto Rico. We need to address one more entity, the United States of America. What is the United States of America? As it turns out, there are two entities called the United States of America. The first and original mentioned in the preamble and Article 2 of the Constitution of the United States was formally created in the Articles of Confederation. But sometime after the Civil War, probably early in the 20th century, a second United States of America came into being. The second is a political alliance or compact of the insular possessions of the United States. Here I'm going to introduce evidence secured by John M. Oman, that's spelled capital O-H-M-A-N, that's capital O, lowercase h-M-A-N, an Idaho Falls, Idaho attorney. In the case styled Diversified Metal Products Incorporated versus T-Bow Company Trust, Internal Revenue Service, and Steve Morgan, case capital C, capital V, 93-4117, filed in the District Court of the 7th Judicial District of the State of Idaho, the Boonville County Magistrates Court, Oman filed an impleader petition. This is the same case that I read to you, I think it was a week ago. Diversified Metal was served a notice of levy for money owed to the T-Bow Trust. In order to determine rightful ownership, Oman filed the interpleader action on behalf of Diversified Metal. In his complaint, he stipulated facts. His fact number 4 is as follows. Defendant Internal Revenue Service, IRS, is an agency of the United States government. In her January 24, 2000 response, U.S. Attorney Betty H. Richardson made the following correction to Oman's averment. Here's what she said, and I read it to you. In her response, number 4, denies that the Internal Revenue Service is an agency of the United States government, but admits that the United States of America would be a proper party to this action. And remember, folks, this is me now, not Dan Menner. Remember, I talked to you about that these are all different entities. Back to Dan Menner. This is something I've tried to impress on people for almost 2 years, but few grasp the implications. The Constitution for the United States creates and vests authority in a governmental entity known as the United States or United States government. While it is for the United States of America, the Constitution vests absolutely no authority in the United States of America. Anytime the United States prosecutes as case, whether civil or criminal, it must be in the name and by authority of the United States, not the United States of America. The only place the United States of America has any standing is in territorial courts in insular possessions of the United States. Then the styling must be United States of America, SS, President of the United States. See Title 48 of the United States Code for particulars relating to Puerto Rican and Virgin Island courts. And I will add also that also applies to Guam courts. If we read notes following the current 18 United States Code, Section 1001, we find that the United States of America is currently defined as an agency of the United States. In the context of the Downs versus Bidwell decision, we find that these insular possessions, which are not incorporated in the constitutional scheme, are foreign to the United States, in effect, to the Union of States. Therefore, this political alliance or compact, known as the United States of America, which first appeared in 1918 legislation, is a government foreign to the United States and the several states, even though the member insular possessions belong to the United States. The Richardson correction verifies that the Internal Revenue Service is not an agency of the United States government, but the United States of America, clearly a distinct and different entity, would be a party of interest. It would be difficult to be any clearer on the subject, and the Richardson correction tells us that people such as U.S. attorneys, attorneys in the Department of Justice, and federal judges are fully aware of the difference. And this is me talking again, just like I've been telling you for years and years and years. Continue with Dan Mitter's letter. Michael Bufkin, a Dundee, Illinois attorney, undertook a delightful project on December 18, 1998. He sent a Freedom of Information Act request to the Department of Treasury asking for documentation of authority for the Department of Justice to defend Internal Revenue Service personnel in civil or criminal cases. In an August 2, 1999 response, Leslie Howard in the National Internal Revenue Service Office responded with the following. A search was performed with the Office of Tax Crimes Criminal Investigation and with the Assistant Chief Counsel Disclosure Litigation, and we have no documents responsible to your request. However, you may forward a copy of your request to the U.S. Attorney General's office within the Department of Justice. Well, Bufkin did just that. In response to his September 21, 1999 FOIA to the Attorney General, Thomas J. McIntyre informed Bufkin that we have conducted a search of the appropriate indices to criminal division records and did not locate any records responsive to your request. We don't know who has lawful authority to defend IRS personnel, but the Department of Justice and U.S. attorneys don't. Possibly the foreign United States of America, that is, principle of interest and benefits from IRS initiatives, has a raft of attorneys ready to defend these foreign agents. As chance would have it, one of the people in our group recently received certification of documents on Internal Revenue Service Austin Region Stationery that is headed United States of America, comma, Department of the Treasury, comma, Internal Revenue Service. The certification letters are dated November 16, 1999. What we are dealing with amounts to invasion of a foreign government accommodated by our respective state governments. However, thanks to the diligence of people approaching IRS tyranny from several directions, we about have the whole nut documented and broken down. With the context of what I've written, the Cooper article that follows will have more significance. Signed, Dan Metter, Ponca City, Oklahoma. I'm going to play a little music now so I can take a drink of coffee, and then we'll start the article. It's going to take a couple of nights to get through it. It's long, it's lengthy. There are a lot of legal sites. You should have pen and paper by your side. You should be listening very carefully, and you should take notes. You can do that, can't you? Take notes, I mean? I think so. Well, here we go, folks. I hope you're all settled in and got pen and paper by your side, ready to listen. This article was originally published in the September edition of Veritas National Newspaper as the headline, article. It made history because up until Wayne Benson and I pooled our research and I wrote this article, everybody had come to a dead end, a brick wall. They weren't able to go any further because they could not find the true nature of the Internal Revenue Service. In fact, they couldn't even find that it existed in the United States government. And that, folks, is because it does not. So listen very, very carefully. And write. You must write. And you must duplicate the research so that you know that I'm not lying to you. See, unless you get off your butt and go out and do the research yourself, like I've always told you, listen to everyone, read everything, believe absolutely nothing unless you can prove it in your own research, you'll never know whether I'm sitting here feeding you the biggest crock of crap that you ever heard in your life or whether I'm telling you the truth. Now, I am telling you the truth, but you've got to verify that on your own. You can't take my word for it. This is the age of deception. Believing and trusting people is what got us to this point. And it's wrong to do that. IRS BATF Criminal Fraud by William Cooper, with research combined between myself and Wayne Benson. Quote, the Congress shall have power to lay and collect taxes, duties, imposts, and excise, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. End quote. Constitution for the United States of America, Article 1, Section 8, Paragraph 1. Now, the United States of America I just quoted to you is not the same United States of America that is the Union of the Insular Possessions that represents the foreign power that is encroaching upon the states. Quote, no capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. End quote. Constitution for the United States of America, Article 1, Section 9, Paragraph 4. Investigation of the alleged Internal Revenue Service and the Bureau of Alcohol, Tobacco, and Firearms has disclosed a broad, premeditated conspiracy to defraud the citizens of the United States of America. Examination of the United States Code, the Code of Federal Regulations, the statutes at large, congressional record, the Federal Register, and Internal Revenue manuals too numerous to list, reveals a crime of such magnitude that words cannot adequately describe the betrayal of the American people. What we have uncovered has clearly been designed to circumvent the limitations of the Constitution for the United States and implement the Communist Manifesto within the 50 states. Marx and Engels claimed that in the effort to create a classless society, a graduated income tax could be used as a weapon to destroy the middle class. Magic is the art of illusion. Those who practice magic are called magi. They have created a web of obfuscation and confusion in the law. When the courts have ruled them unconstitutional or unlawful, they merely stepped outside jurisdiction and venue. By fooling the people, they continue the crime. These magicians have convinced Americans that we have a status we do not. We are led to believe we must do things that are not required. Through the clever use of language, the government promotes fraud. The Bureau of Internal Revenue and the alleged Internal Revenue Service were not created by Congress. These are not organizations or agencies of the Department of the Treasury or of the federal government. They appear to be operated through pure trusts administered by the Secretary of the Treasury, the trustee. The settlor of the trust and the beneficiary or beneficiaries are unknown. According to the law governing trusts, the information does not have to be revealed. The organization, listen to me carefully, folks. You can go check this out real easy. All of this, you can check it out real easy. I'll give you sites for everything. The organization of the Department of the Treasury can be found in 31 United States Code. That's 31 United States Code, Chapter 3. You will not find the Bureau of Internal Revenue, the Internal Revenue Service, the Secret Service, or the Bureau of Alcohol, Tobacco, and Firearms listed as they must be listed as required by law, but they are not. We learned that the Bureau of Internal Revenue, Internal Revenue, Internal Revenue Service, Internal Revenue Service, and I'm saying the same thing, but in the law, they are different depending upon capitalization. So when I say the Bureau of Internal Revenue, and then Internal Revenue, that's Internal Revenue with no capitalization, and then Internal Revenue Service with capital I, capital R, small s, and then Internal Revenue Service with no capitalization, Official Internal Revenue Service with capital O, capital I, capital R, capital S, the Federal Alcohol Administration, Director, Alcohol, Tobacco, and Firearms Division, and the Bureau of Alcohol, Tobacco, and Firearms are all one organization. We found this obfuscated but definitely proved in the law. And you're going to hear the sites, so listen. The investigation found that except for the very few who are engaged in specific activities, the citizens of the 50 states of the United States of America have never been required to file or to pay income taxes. The federal government is engaging in constructive fraud on a massive scale. Americans who have been frightened into filing and paying income taxes have been robbed of their money. Millions of lives have been ruined. Hundreds of thousands of innocent people have been imprisoned on the pretense they violated laws that do not exist. Some have been driven to suicide. Marriages have been destroyed. Property has been confiscated to pay taxes that were never owed. During the Civil War, Abraham Lincoln imposed a war tax upon the citizens. The war tax lawfully applied only to those citizens who resided within the Federal District of Columbia and federally owned territories, dockyards, naval bases, or forts, and those who were considered to be in rebellion against the Union. This was done by executive order, not by legislation passed by the Congress. Many citizens of the several states volunteered to pay. After the war, the tax was repealed. This left the impression that the President and Congress could levy an unapportioned direct tax upon citizens of the several states, when, in fact, no such tax had ever been imposed. The tax was not fraud, as nothing was done to deceive the people. Those who were deceived, in fact, deceived themselves. In the last century, the United States acquired by conquest the territory of the Philippine Islands, Guam, and Puerto Rico. The Philippine Customs Administrative Act was passed by the Philippine Commission during the period from September 1st, 1900 to August 31st, 1902, to regulate trade with foreign countries and to create revenue in the form of duties, imposts, and excises. The act created the federal government's first trust fund, called Trust Fund Number 1, the Philippine Special Fund, Customs and Duties. 31 United States Code, Section 1321. The act was administered under the general supervision and control of the Secretary of Finance and Justice. The Philippine Commission passed another act known as the Internal Revenue Law of 1904. This act created the Bureau of Internal Revenue and the federal government's second trust fund, Internal Revenue, 31 United States Code, Section 1321. In the Act, Article Section 2, we find, quote, there shall be established a Bureau of Internal Revenue, the chief officer of which bureau shall be known as the Collector of Internal Revenue. He shall be appointed by the civil governor, with the advice and consent of the Philippine Commission, and shall receive a salary at the rate of 8,000 pesos per annum. The Bureau of Internal Revenue shall belong to the Department of Finance and Justice, end quote. And in Section 3 we find, quote, the Collector of Internal Revenue, under the direction of the Secretary of Finance and Justice, shall have general superintendence of the assessment and collection of all tax and excises imposed by this Act or by any act amendatory thereof, and shall perform such other duties as may be required by law, end quote. It was clear that the Customs Administrative Act was to fall within the jurisdiction of the Bureau of the Internal Revenue, which bureau was to be responsible for all taxes and excise imposed by this Act, which clearly include import and export excise taxes. This effectively merged Customs and Internal Revenue in the Philippines. When Prohibition was ratified in 1919 with the 18th Amendment, the government created federal bureaucracies to enforce the outlaw of alcohol. As protest and resistance to Prohibition increased, so did new federal laws and the number of bureaucrats hired to enforce them. After much bloodshed and public anger, Prohibition was repealed with the 21st Amendment, which was ratified in 1933. In 1933, President Roosevelt declared a banking emergency. The Congress gave the President dictatorial powers under the War Powers Act of 1917. Congress used the economic emergency as the excuse to give blanket approval to any and all presidential executive orders. Roosevelt, with a little help from his socialist friends, was prolific in his production of new legislation and legislation through executive orders, an unconstitutional act. But he cranked them out. In 1935, the Public Administration Clearinghouse wrote, and Roosevelt introduced, the Federal Alcohol Act. Congress passed it into law. The act established the Federal Alcohol Administration. But that same year, the Supreme Court, in a monumental ruling, struck down the act, among many others on a long list of draconian and New Deal laws. The Federal Alcohol Administration did not go away. It became involved in other affairs, placed in a sort of standby status. At some unknown date prior to 1940, another Bureau of Internal Revenue was established in Puerto Rico. The 62nd Trust Fund was created and named Trust Fund Number 62, Puerto Rico Special Fund, Internal Revenue. Note that the Puerto Rico Special Fund has Internal Revenue capital I and capital R. The Philippine Special Fund, Internal Revenue, is all in lowercase letters. Between 1904 and 1938, the China Trade Act was passed to deal with opium, cocaine, and citric wines shipped out of China. It appears to have been administered in the Philippines by the Bureau of Internal Revenue. We studied a copy of the Code of Federal Registrations of the United States of America in force June 1st, 1938, Title 26, Internal Revenue, Chapter 1, Parts 1 through 137. On page 65, it makes reference to the China Trade Act, where the first use of such terms as income, credits, withholding, assessment, and collection deficiencies, extension of time for payment, and failure to file return appeared. The entire substance of Title 26 deals with foreign individuals, foreign corporations, foreign insurance corporations, foreign ships, income from sources within possessions of the United States, citizens of the United States and domestic corporations deriving income from sources within a possession of the United States and China Trade Act corporations. Do any of those apply to any of you? They certainly don't apply to me. All of the taxes covered by these laws concerned the imposts, excise taxes, and duties to be collected by the Bureau of Internal Revenue for such items as narcotics, alcohol, tobacco, and firearms. The alleged Internal Revenue Service likes to make a big to-do about the fact that Al Capone was jailed for tax evasion. The IRS will not tell you that the tax Capone evaded was not income tax as we know it, but the tax due on the income from the alcohol which he had imported from Canada. If he had paid the tax, he would not have been convicted and would probably be running some very large multinational corporation today. The Internal Revenue Act of 1939 was clearly concerned with all taxes, imposts, excises, and duties collected on trade between the possessions and territories of the United States and foreign individuals, foreign corporations, or foreign governments. The income tax laws have always applied only to the Philippines, Puerto Rico, District of Columbia, U.S. Virgin Islands, Guam, Northern Mariana Islands, territories, and insular possessions. Under the Reorganization Plan No. 3 of 1940, which appears at 5 United States Code Service 903, the Federal Alcohol Administration and offices of members and administrators thereof were abolished, and their functions directed to be administered under direction and supervision of Secretary of Treasury through Bureau of Internal Revenue. We found this history in all of the older editions of 27 United States Code Service, Section 201. It has been removed from current editions so that you can't find this out. Only 2 bureaus of Internal Revenue have ever existed in the history of this country, one in the Philippines and another in Puerto Rico. Events that have transpired tell us that the Federal Alcohol Administration was, in fact, absorbed by the Puerto Rico Trust No. 62, Internal Revenue, Puerto Rico, because the Philippine Islands were granted their independence and we no longer have jurisdiction over that, what used to be our territory. Don't forget to tune in tomorrow night, folks, as we continue. Make sure you have your pad and pencil by your side, because I'm going to blow your brains out with this information. And I cite everything. And unless you've gone and looked it up and can prove me to be wrong, don't you ever let me hear you call me a liar, because I'll make you look like a fool. Good night. God bless each and every single one of you. Good night, Annie Pooh and Allison. I love you.
Thank you for listening to the Urban Odyssey podcast. If you enjoy the content we release, please consider supporting us by subscribing to our Substack. A monthly membership is only $5 per month. If you decide to buy a year-long membership, it's only $50 for the entire year. Purchase a membership now at theofficialurban.substack.com. Again, that is theofficialurban.substack.com. You can also find all of my free resources that I share, such as free books, links, documentaries, and more, at bio.link/officialurban. Again, that's bio.link/officialurban. Now, let's get back to the audio.
Good evening, ladies and gentlemen. You're listening once again to the Hour of the Time. I'm William Cooper. I want to thank all of you who sent your donations for March. Those of you who have not, please get them in the mail as soon as possible so we can try to catch up on the expenses around here. The address is HOTT, H-O-T-T, in care of 101.1 FM, P.O. Box 940, Eager, spelled E-A-G-A-R, Arizona, 85925. That's HOTT, H-O-T-T, in care of 101.1 FM, P.O. Box 940, Eager, Arizona, 85925. Remember, folks, this broadcast, the website, everything that we do exists only through your contributions from now on. Well, tonight we're going to continue with what I started last night, which is the biggest heist in history. And I'm going to take up exactly, where we stopped. So make sure you've got your pen and paper. Make sure that you're comfortable and settle in to take some notes, because you need to do that. FAA becomes the BIR. That's the Federal Alcohol Administration, becomes the Bureau of Internal Revenue. Under the Reorganization Plan number 3 of 1940, which appears at 5 United States Code Service 903, the Federal Alcohol Administration and offices of members and administrators thereof were abolished, and their functions directed to be administered under direction and supervision of Secretary of Treasury through Bureau of Internal Revenue. We found this history in all of the older editions of 27 United States Code Service, Section 201. It has been removed from current editions. Only 2 bureaus of Internal Revenue have ever existed, one in the Philippines and another in Puerto Rico. Events that have transpired tell us that the Federal Alcohol Administration was absorbed by the Puerto Rico Trust number 62, Internal Revenue. World War II was the golden opportunity. Americans were willing to sacrifice almost anything if they thought that sacrifice would win the war. In that atmosphere, Congress passed the Victory Tax Act. It mandated an income tax for the years 1943 and 1944 to be filed in the years 1944 and 1945. The Victory Tax Act automatically expired by law at the end of 1944. The federal government, with the clever use of language, created the myth that the tax was applicable to all Americans. Because of their desire to win the war, Americans filed and paid the tax voluntarily. Because of ignorance of the law, Americans filed and paid the tax. See, there were some who filed and paid because they thought it was their patriotic duty, even though they didn't have to, and they knew that. There were others who did it because they were ignorant. They had no idea that they weren't required to file and pay the tax. The government, however, promoted the fraud and threatened those who objected. Americans forgot that the law expired in 2 years, and nobody reminded them. When the date had come and gone, they continued to keep records. They continued to file, and they continued to pay the tax. The federal government continued to print returns and collect the tax. Never mind the fact that no citizen of any of the several states of the Union was ever liable to pay the tax in the first place. The fiction that because it was an excise tax it was legal or lawful is absolutely not true. The power of the federal government is limited to its own property, as stated in Article 1, Section 8, Paragraph 17, and to regulate commerce with foreign nations and among the several states and with the Indian tribes, as stated in Article 1, Section 8, Paragraph 3. 18 United States Code, Section 921, definitions states, the term interstate or foreign commerce includes commerce between any place in a state and any place outside of that state, or within any possession of the United States, not including the Canal Zone, or the District of Columbia, but such term does not include commerce between places within the same state, but through any place outside of that state. The term state includes, and in the law, includes means limited to, ladies and gentlemen, doesn't mean in addition to. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, and the possessions of the United States, not including the Canal Zone. Only employees of the federal government, residents of the District of Columbia, residents of naval bases, residents of forts, U.S. citizens of the Virgin Islands, Puerto Rico, territories, and insular possessions were lawfully required to file and pay the victory tax. In 1953, the United States relinquished control over the Philippines. Why do the Philippine Pure Trusts, number 1, customs and duties, and number 2, internal revenue, continue to be administered today? Who are the settlers of the trusts? What is done with the funds in the trusts? What businesses, if any, do these trusts operate? Who are the beneficiaries? Coincidentally, on July 9, 1953, the Secretary of the Treasury, G.M. Humphrey, by virtue of the authority vested in me, changed the name of the Bureau of Internal Revenue, BIR, to Internal Revenue Service when he signed what is now Treasury Order 150-06. This was an obvious attempt to legitimize the Bureau of Internal Revenue. Without the approval of Congress or the President, Humphrey, without any legal and lawful authority, tried to turn a pure trust into an agency of the Department of the Treasury. His actions were illegal and unlawful, but went unchallenged. Did he change the name of the BIR in Puerto Rico or the BIR in the Philippines? In 1954, the United States and Guam became partners under the Mutual Security Act. The Act and other documents make reference to the definition of Guam and the United States as being interchangeable. Do you have any idea how much law that could affect? Do you have any idea how that could fool you if you're reading the law and you're reading the word United States and it's being used in place of the word Guam? In the same year, the Internal Revenue Code of 1954 was passed. The code provides for the United States and Guam to coordinate the individual income tax. Pertinent information on the tax issue may be found in 26 CFR 301.7654-1, Constitution of U.S. and Guam Individual Income Taxes. 26 CFR 7654-1, small e, military personnel in Guam. 48 United States Code, section 1421, small I, income tax laws defined. The Constitution, ladies and gentlemen, forbids unapportioned direct taxes upon the citizens of the several states of the 50 states of the Union. Therefore, the federal government must trick or defraud people into volunteering to pay taxes as U.S. citizens of either Guam, the Virgin Islands, or Puerto Rico. I know it sounds insane, but it is absolutely true, and it's absolutely the way that it works. On June 6, 1972, Acting Secretary of the Treasury, Charles E. Walker, signed Treasury Order number 120-01, which establishes the Bureau of Alcohol, Tobacco, and Firearms. He did this with the stroke of his pen, citing, guess what? By virtue of the authority vested in me as Secretary of the Treasury, including the Authority and Reorganization Plan number 26 of 1950, he ordered the transfer, as specified herein, the functions, powers, and duties of the Internal Revenue Service arising under laws relating to alcohol, tobacco, firearms, and explosives, including the Alcohol, Tobacco, and Firearms Division of the Internal Revenue Service, to the Bureau of Alcohol, Tobacco, and Firearms, hereinafter referred to as the Bureau, which is hereby established. That's what he penned. He said, the Bureau shall be headed by the Director, Alcohol, Tobacco, and Firearms, hereinafter referred to as the Director, The director shall perform his duties under the general direction of the Secretary of the Treasury, hereinafter referred to as the Secretary, and under the supervision of the Assistant Secretary, Enforcement, Tariff, and Trade Affairs and Operations, hereinafter referred to as the Assistant Secretary. It's not confusing yet, folks, but if you think you're confused now, just hold on a few minutes. Treasury Order 120-01 assigned to the new BATF Chapters 51, 52, 53 of the Internal Revenue Code of 1954 and Sections 7652 and 7653 of such code. Chapters 61 through 80 inclusive of the Internal Revenue Code of 1954. The Federal Alcohol Administration Act, 27 United States Code Chapter 8, which in 1935 the Supreme Court had declared unconstitutional within the several states of the Union. 18 United States Code Chapter 44, Title, Roman numeral 7, Omnibus Crime Control and Safe Streets Act of 1968, 18 United States Code, Appendix, Sections 1201, 1203. That's 1201 through 1203. 18 United States Code 1262 through 1265, 1952 and 3615, etc. Mr. Walker then makes a statement within Treasury Order 120-01 that is very revealing. The terms Director, Alcohol, Tobacco, and Firearms Division, and Commissioner of Internal Revenue, wherever used in regulations, rules, and instructions and forms issued or adopted for the administration and enforcement of the laws specified in paragraph 2 hereof, which are in use on the effective date of this order, shall be held to mean the Director. Walker seemed to branch the Internal Revenue Service, IRS, creating the Bureau of Alcohol, Tobacco, and Firearms, BATF, and then, with that statement that I just read to you, joined them back together into one entity. In the Federal Register, Volume 41, Number 180 of Wednesday, September 15th, 1976, we find the term Director, Alcohol, Tobacco, and Firearms Division has been replaced by the term Internal Revenue Service. Not confused enough? Stay tuned. You see how they use words and obfuscate the law? We found this pattern of deception and obfuscation everywhere we looked during our investigation. For further evidence of the fact that the Internal Revenue Service and the Bureau of Alcohol, Tobacco, and Firearms are one and the same organization, check 27 U.S.C.A. Section 201. This, ladies and gentlemen, is how the Magi, or the magicians, perform their magic. Secretary Humphrey, with no authority, creates an agency of the Department of the Treasury called Internal Revenue Service out of thin air, from an offshore pure trust called Bureau of Internal Revenue. We all know that Congress is the only governmental body that can create an agency of any portion of the government. The settlor and beneficiaries of the trust are unknown. The trustee is the Secretary of the Treasury. Acting Secretary Walker further launders the trust by creating from the alleged Internal Revenue Service the Bureau of Alcohol, Tobacco, and Firearms. But unlike Humphrey, Walker assuages himself of guilt when he nullified the order by proclaiming the terms Director, Alcohol, Tobacco, and Firearms Division, and Commissioner of Internal Revenue, wherever used in regulations, rules, and instructions and forms issued or adopted for the administration and enforcement of the laws specified in paragraph 2 hereof, which are in effect or in use on the effective date of this order, shall be held to mean the director. Walker created the Bureau of Alcohol, Tobacco, and Firearms from the Alcohol, Tobacco, and Firearms Division of Humphrey's Internal Revenue Service. He then says that what was transferred is the same entity as the Commissioner of Internal Revenue. You see, he knew he could not create something from nothing without the authority of Congress. So he made it look like he did something that he had, in fact, not done. But it sure confuses anyone who's trying to find the truth. And to compound the fraud, the Federal Register published the unbelievable assertion that a person had been replaced with a thing. The term Director, Alcohol, Tobacco, and Firearms Division has been replaced with the term Internal Revenue Service. The Federal Alcohol Administration, which administers the Federal Alcohol Act, and offices of members and administrator thereof were abolished, and their functions were directed to be administered under direction and supervision of Secretary of Treasury through Bureau of Internal Revenue, now Internal Revenue Service. The Federal Alcohol Act was ruled unconstitutional within the 50 states, so was transferred to the Bureau of Internal Revenue, which is an offshore trust, which became the Internal Revenue Service, which gave birth to the Bureau of Alcohol, Tobacco, and Firearms, and somehow the term Director, Alcohol, Tobacco, and Firearms Division, which is a person with the BATF, spawned the alleged Internal Revenue Service via another flick of the pen on September 15, 1976. In a brilliant flash of logic, Wayne C. Benson determined that he could check these facts by filing a Freedom of Information Act request, asking the BATF to name the person who administers the Federal Alcohol Act. Now, folks, if we were wrong, a reply stating that no record exists as to any name of any person who administers the Act. But the request was submitted to the BATF. Now, listen to me very carefully. The request was submitted to the Bureau, Alcohol, Tobacco, and Firearms. But the reply came on July 14th, Well, that's a typo. The reply came on July 14th. I'm not going to read the date here because it's a typo. It's wrong. The reply came on July 14th, was in the early portion of the 90s, from the Secret Service, an unexpected source, which discloses a connection we had not suspected. The reply states that John McGaugh of the Bureau of Alcohol, Tobacco, and Firearms of the Department of the Treasury administers the Federal Alcohol Act. You may remember from the Waco hearings that John McGaugh was the Director, Alcohol, Tobacco, and Firearms during the Waco massacre. All of our research was confirmed by that admission. Now, despite all this pen flicking and the smoke and mirrors, there is no such organization. Listen to me carefully, ladies and gentlemen. Make sure you check it in the law. Don't take my word for anything that I'm telling you. Despite all the pen flicking and the smoke and mirrors, there is no such organization of the Department of the Treasury known as Internal Revenue Service or the Bureau of Alcohol, Tobacco, and Firearms. 31 United States Code is Money and Finance, and therein is published and required by law to be published the laws pertaining to the Department of the Treasury, known as DOT. 31 United States Code, Chapter 3, is a required by law statutory list of the organizations of the Department of the Treasury. Internal Revenue Service and our Bureau of Alcohol, Tobacco, and Firearms and the Secret Service are not listed within 31 United States Code as agencies or organizations of the Department of the Treasury. In fact, they are not listed at all. They are only referenced, however, as to be audited by the Comptroller General in 31 U.S.C. Section 713. We have already demonstrated that both of these organizations are in reality the same organization. Where we find one, we will surely find the other. In 27 CFR, Chapter 1, Section 250.11, definitions, we find United States Bureau of Alcohol, Tobacco, and Firearms Office. The Bureau of Alcohol, Tobacco, and Firearms Office in Puerto Rico. That's the definition. And Secretary. Remember, they referred earlier that the Secretary of the Treasury would be referred to as Secretary. The definition of Secretary is the Secretary of Puerto Rico. And Revenue Agent is defined as any duly authorized Commonwealth Internal Revenue Agent of the Department of the Treasury of Puerto Rico. These are the only definitions in Title 26 and Title 27, which are the Internal Revenue Code and the code governing the Bureau of Alcohol, Tobacco, and Firearms. There are no other definitions for these terms, and in the law, there must be if they are different from any given. Remember that Internal Revenue is the name of the Puerto Rico Trust number 62. So it is perfectly logical and reasonable that a revenue agent works as an employee for the Department of the Treasury of the Commonwealth of Puerto Rico. Where is the alleged Internal Revenue Service? The Internal Revenue Code of 1939, also known as Internal Revenue Code of 1954, etc., 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 27 CFR, refers to Title 26 as relevant to Title 27, as per 27 CFR, Chapter 1, Section 250.30, which states that 26 United States Code 5001, small a, 1, is governing a 27 U.S.C. law. In fact, 26 U.S.C. Chapters 51, 52, and 53 are the alcohol, tobacco, and firearms taxes administered by the Internal Revenue Service, alias Bureau of Internal Revenue, alias Virgin Islands Bureau of Internal Revenue, alias Director, Alcohol, Tobacco, and Firearms Division, alias Internal Revenue Service. According to 26 CFR, that's Code of Federal Regulations, Section 1.6001-1, small d, records, no one, listen to me carefully, no one is required to keep records or file returns unless specifically notified by the district director by notice served upon him to make such returns, render such statements, or keep such specific records as will enable the district director to determine whether or not such person is liable for tax under subtitle capital A of the Code. Now, those are the numbers they give you on the 1040. Have you been notified by the district director to keep such records, render such statements, keep such specific forms, and file such returns? I doubt it. But that's what the law requires if you are one of those made liable. 26 CFR states that this rule includes state individual income taxes. State in the code means the District of Columbia, U.S. Virgin Islands, Guam, Northern Mariana Islands, Puerto Rico, territories, and insular possessions. 44 United States Code says that every regulation or rule must be published in the Federal Register. Not that it might be, not that it can be, not that it's up to anybody's discretion. It says specifically that every regulation or rule must be published in the Federal Register. It also states that every regulation or rule must be approved by the Secretary of the Treasury. If there is no regulation, there is no implementation of law. Listen to this. There is no regulation governing failure to file a return. There is no computer code for failure to file. The only thing we could find was a requirement stating where to file an income tax return. It can be found in 26 CFR Section 1.6091-3, which states that. Are you ready for this? Income tax returns are required to be filed with the Director of International Operations. Now, why would a citizen of the state of Arizona be required to file an income tax return with the Director of International Operations? And who is the Director of International Operations? No one, ladies and gentlemen, in government is allowed to do anything unless they have been given specific written authority, or someone who has been given authority in the law by the Congress gives that person a delegation of authority order, spelling out exactly what they can and cannot do under that specific order. We combed, and I mean combed, from one end to the other, the Department of the Treasury's Handbook of Delegation Orders, and we found that no one in the Internal Revenue Service or the Bureau of Alcohol, Tobacco, and Firearms has any authority to do all of the things that they have been doing to Americans for years. Delegation Order number 115, Revision 5, of May 12, 1986, is the only delegation of authority to conduct an audit. It says, listen very carefully, that the Internal Revenue Service and the Bureau of Alcohol, Tobacco, and Firearms can only audit themselves, and only for an amount of $750 or less. Any amount above that amount must be audited by the Comptroller General, according to Title 31, United States Code. Listen to me carefully. No other authority to audit anyone exists, period. No Internal Revenue Service or BATF agent or representative can furnish us with any law, rule, or regulation which gives them the authority to audit anyone other than themselves. Order number 191 states that they can levy on property, but only if that property is in the hands of third parties. In other words, if you own a Jeep and you loan it to Joe Blow, who is your neighbor, they can levy on that Jeep while Joe Blow is driving it, but not while it's in your possession or on your property. And only if it's subject to the law to be levied upon, which we have already proven it is not. The manual states on page 1100-40.2 of April 21st, 1989, Criminal Investigation Division, that the Criminal Investigation Division enforces the criminal statutes applicable to income, estate, gift, employment, and excise tax laws involving United States citizens residing in foreign countries and non-resident aliens subject to federal income tax filing requirements by developing information concerning alleged criminal violations thereof, evaluating allegations and indications of such violations, to determine investigations to be undertaken, investigating suspected criminal violations of such laws, recommending prosecution when warranted, and measuring effectiveness of the investigating process. There is no other authorization anywhere for the Criminal Investigation Division to do anything with any person, with any human, with any man, with any family, with any property, within any territorial boundary of any of the several states of the Union, period. Don't believe me? Get your nose in the books. On page 1100-40.1, It states in 1132.7 of April 21st, 1989, Director, Office of Taxpayer Service and Compliance, is responsible for operation of a comprehensive enforcement and assistance program for all taxpayers under the immediate jurisdiction of the Assistant Commissioner, International, and directs the full range of collection activity on delinquent accounts and delinquent returns for taxpayers overseas in Puerto Rico and United States possessions and territories. No state of the several states of the Union is a possession or territory of the United States. 1132.72 of April 21st, 1989. Collection Division says that it executes the full range of collection activities on delinquent accounts, which includes securing delinquent returns involving taxpayers outside the United States and those in United States territories, possessions, and in Puerto Rico. The United States Attorney's Manual, Title VI, Tax Division, Chapter 4, page 16, October 1st, 1988, 6-4.270, Criminal Division Responsibility states, the Criminal Division has limited responsibility for the prosecution of offenses investigated by the Internal Revenue Service. Those offenses are excise violations involving liquor tax, narcotics, stamp tax, firearms, wagering, and coin-operated gambling and amusement machines. Malfeasance offenses committed by Internal Revenue Service personnel, forcible rescue of seized property, corrupt or forcible interference with an officer or employee acting under Internal Revenue laws, and unauthorized mutilation, removal, or misuse of tax stamps. See 28 CFR S 0.70. That's section 0.70. Acts of Congress. You're all going to like this. We found this revelation in 28 United States Code, Rule 54, small c. Write that down. Look it up. You'll get a big kick out of it. 28 United States Code, Rule 54, small c. Application of terms. As used in these rules, the following terms have the designated meanings. Act of Congress includes any act of Congress locally applicable and enforced in the District of Columbia, in Puerto Rico, in a territory, or in an insular possession. That's the definition of Act of Congress in the Internal Revenue and the BATF codes. Now remember, I told you in the law, includes means limited to. Limited to. 28 U.S.C. is the rules of the courts, ladies and gentlemen. That's what I just read to you from. And it's the rules of the courts. And it was written and approved by the justices of the United States Supreme Court. The Supreme Court, in writing 28 U.S.C., has already ruled upon this issue. It is the law. Now, let me ask you, how can the Supreme Court write law? Hello? You see, no rules of any court have ever been legislated or enacted into any law by any court. And if you know that, you are not bound to follow the rules of the court. Wake up. You see, a court, even the United States Supreme Court, cannot make law. Period. Where does the money go that is paid into the Internal Revenue Service? Well, we know that a whole bunch of it spends at least a year in what is called a quad zero account under an individual master file, after which time the director of the Internal Revenue Service Center can apparently do whatever he wants with the money. It is sometimes dispersed under Treasury Order 91, Revision 1, May 12, 1986, which is a service agreement between the Internal Revenue Service and the Agency for International Development, known as AID, or AID. When William Casey, director of the Central Intelligence Agency during the Iran-Contra affair, was the head of AID, he funneled hundreds of millions of dollars to the Soviet Union, which money was spent building the Kama River Truck Factory, the largest military production facility for tanks, trucks, armored personnel carriers, and other wheeled vehicles in the entire world, and that's before our automobile and vehicle industry left this country to make cars in third world nations. The Kama River factory has a production capability larger than all of the combined automobile and truck manufacturing plants that ever existed in the United States. And during that time, the Soviet Union was our avowed enemy. That's treason. The agreement states, authority is hereby delegated to the Assistant Commissioner, International, to develop and enter into the service agreement between the Treasury Department and the Agency for International Development. The Secretary of the Treasury is always appointed Governor of the International Monetary Fund. In accordance with the international agreement that created the IMF, the Secretary of the Treasury is paid by the IMF while acting as the Governor. The Secretary of the Treasury holds the following positions concurrently with the appointment as Secretary of the Treasury, making him an unregistered agent of several foreign powers. Number 1, the U.S. Governor of the International Monetary Fund. Number 2, Governor of the International Bank for Reconstruction and Development. Number 3, U.S. Governor of the African Development Bank. Number 4, U.S. Governor of the Asian Development Bank. Number 5, U.S. Governor of the African Development Fund. Number 6, U.S. Governor of the European Bank for Reconstruction and Development. The Secretary of the Treasury receives a salary from each of these organizations, which literally make him an unregistered agent of several foreign powers. By birth, you and I, each of us, is a citizen of the state of New Jersey, or a citizen of the state of California, or a citizen of the state of Florida, or a citizen of the state of Arizona, or the state of whatever state you were born in. And at the same time, we are all citizens of the United States and are not subject to acts of Congress other than the 18 grants of powers specifically cited in the Constitution for the United States of America. People who are born or who reside within the Federal District of Columbia, Guam, the U.S. Virgin Islands, Puerto Rico, the Northern Mariana Islands, any territory, on any naval base or dockyard, within forts, or within insular possessions are called U.S. citizens and are subject to acts of Congress. In fact, all acts of Congress. Within the law, words have meanings. They are not the same meanings that most of us accept in our common day-to-day usage. Our Constitution is the Constitution for the United States of America. The one called the U.S. Constitution is actually, in fact, the Constitution of Puerto Rico. Look it up. We are subject to the laws of the jurisdiction which we volunteer to accept. In the law governing income tax, income is defined as foreign earned income, offshore oil well or windfall profits, and war profits. A return is prepared by a taxpayer to submit to the federal government taxes that he or she has collected. A taxpayer is one who collects taxes and submits the taxes as a return to the federal government. An employee is one who is employed by the federal government. An employer is the federal government. An individual is a citizen of Guam or the U.S. Virgin Islands. A business is defined as a government, a bank, or an insurance company. A resident is an alien citizen of Guam, the U.S. Virgin Islands, or Puerto Rico, who resides within one of the 50 states of the United States of America or one of the other island possessions. It's the law. These are the definitions, and they are the only definitions within Title 26 and Title 27 of the United States Code and Title 26 and Title 27 CFR. Don't believe it? Look it up. A Form 1040 is the income tax return for a non-resident alien citizen of the U.S. Virgin Islands residing within one of the 50 states, geographically, of the several states of the United States. If you volunteer that you are a U.S. citizen, you have become a U.S. citizen. If you write or print your name on a line labeled taxpayer, you have become a taxpayer. Since these forms are affidavits which you submit under penalty of perjury, the first time you ever do it, you are stuck with that until you learn how to use the law to get out of it. You have volunteered. And you commit a crime every time you fill one of these forms out and sign stating that you are that which you are not, because every time you do it, you're doing it under penalty of perjury. But the federal government is delighted by your ignorance and will gladly accept your returns and your money. As proof, refer to the Virgin Islands Tax Guide, which states, all references to the district director or to the commissioner of Internal Revenue should be interpreted to mean the director of the Virgin Islands Bureau of Internal Revenue. All references to the Internal Revenue Service, the Federal Depository, and similar references should be interpreted as the Bureau of Internal Revenue, and so forth. Any question interpreting federal forms for use in the Virgin Islands should be referred to the Bureau of Internal Revenue, etc., etc., etc. If you look in the OMB record, that's the Office of Budget and Management, in the record of forms to be used for filing income tax returns to the Internal Revenue Service, you will find that Form 1040 is the form to be used by non-resident aliens who earn income from business dealings within the United States of America. It doesn't apply to you at all, period, under any circumstances. In Internal Revenue Service Publications 6209, Computer Codes for the Internal Revenue Service, TC 150, is listed as the Virgin Islands Returns, and the codes 300 through 398 are listed as U.S. and U.K. tax treaty claims involving taxes on narcotics which were financed in the Cayman Islands and imported into the Virgin Islands. Are you beginning to get the message, folks? When Freedom of Information Act requests have been filed for individual master file for people who are experiencing tax problems with the Internal Revenue Service, every return has been found to contain the above codes except for some which are coded as Guam returns. Every return shows that the unsuspecting citizen is being taxed on income derived from importing narcotics, alcohol, tobacco, firearms, or citric wines into the United States or one of its territories or possessions from a foreign country or from Guam, Puerto Rico, the Virgin Islands, or into the Virgin Islands from the Cayman Islands. CFR 601.103 small a is the only place which tells us who is required to file a return. provided that person has been properly noticed by the district director to keep records and then noticed that he or she is required to file. It states, in general, each taxpayer or person required to collect and pay over the taxes is required to file a prescribed form of return. Remember, I already read you the definition of taxpayer. That's the person who collects the taxes and files the return to the government. Are you a taxpayer? If so, you must be a tax collector, according to the law. This scam, ladies and gentlemen, manifests itself in many different ways, and it depends completely upon your total ignorance and voluntary compliance. In order to maintain the semblance of legality, hats are changed from moment to moment. When you are told to submit records for examination, you are in fact dealing with customs. When you submit an offer in compromise, you are dealing with the Coast Guard. When you are confronted by a special agent of the Internal Revenue Service, you are really dealing with a deputized United States Marshal trained to protect our ambassadors abroad. When you are being investigated by the alleged Internal Revenue Service, you are really dealing with an agent contracted by the Justice Department to investigate narcotics violations. When the alleged Internal Revenue Service charges you with a crime, you are dealing with the Bureau of Alcohol, Tobacco, and Firearms. Only a small part of 26 United States Code is administered by the Internal Revenue Service. Most of the code, ladies and gentlemen, most of the code is administered by the Bureau of Alcohol, Tobacco, and Firearms, including Chapter 61 through 80, which is enforcement. See, the Internal Revenue Service has no powers of enforcement whatsoever. They're revenue officers. They're tax collectors. In addition, 27 CFR is BATF and states in Subpart B, Definitions 250.11, Meaning of Terms, United States Bureau of Alcohol, Tobacco, and Firearms Office is the Bureau of Alcohol, Tobacco, and Firearms Office in Puerto Rico. Every person we find who is being prosecuted by the alleged Internal Revenue Service has a code on their individual master file, putting them in Tax Class 6, which designates that they have violated a law relating to alcohol, tobacco, or firearms. Guess where? Puerto Rico. The Bureau of Alcohol, Tobacco, and Firearms has no venue or jurisdiction within the borders of any of the 50 states of the United States of America, except in pursuit of an importer of contraband alcohol, that's contraband alcohol, contraband tobacco, or contraband firearms, who failed to pay the tax on those items. As proof, refer to the July 30th, 1993 ruling of the United States Court of Appeals for the 7th Circuit, 1, capital F, dot 3, small d, 1511, 1993, United States, capital A, PP, Lexus 19747, where the court ruled in United States versus D.J. Vollmer and Company that the Bureau of Alcohol, Tobacco, and Firearms only has jurisdiction over the first sale of a firearm imported to the country, but they don't have jurisdiction over any subsequent sale thereafter. The feds lie all the time. These are the most despicable, lying, Nazi, Gestapo, jackbooted thugs that you will ever come across. And they are committed treason, and they are destroying lives and businesses and families every day. Attorneys, including your defense attorney, the U.S. Attorney, the United States Attorney, federal judges, and alleged Internal Revenue Service and Bureau of Alcohol, Tobacco, and Firearms personnel routinely lie. In depositions, and on the witness stand to perpetuate the fraud. This they do willingly and with full knowledge that they are committing perjury. Every judge intentionally lies every time he or she gives instructions to a jury in a criminal or tax case brought by the Internal Revenue Service or the Bureau of Alcohol, Tobacco, and Firearms. They all know it. They do it willingly and with malice aforethought. Now, how does the government hire people who will intentionally work to defraud their fellow Americans, to seize their property, to throw them into prison? Most of those who work on the lower levels for the IRS, BATF, and other agencies, ladies and gentlemen, simply do not know the truth. They just do as they are told by their supervisors to earn a living until they can retire. Executives, U.S. attorneys, United States attorneys, federal judges, and others do know and are, with full knowledge and malice aforethought, participating in the crime of the century. Many of these people are paid lots of money. Many of them are paid lots of money to do it, whether or not they're aware that it's wrong. And here's how that happens. They're actually paid to deceive, to commit criminal acts and fraud against the American people. You see, the Internal Revenue Manual, Handbook of Delegation Orders, January 17, 1983, page 1229-91, outlines the alleged Internal Revenue Service's system of monetary awards. Get this. Of up to and including $5,000 for any one individual employee or group of employees in his or her immediate office, including field employees engaged in national office projects and contributions of employees of other government agencies and armed forces members, with the approval of the Deputy Commissioner. Of $5,001 to $10,000 for any one individual or group, with the approval of the Deputy Commissioner. Of $10,001 to $25,000 for any one individual or group, with the Commissioner's concurrence. An additional monetary reward of $10,000 to total $35,000 to the President of the United States of America through Treasury and OPM with the Commissioner's concurrence. That's an impeachable offense. That's a bribe, and it's treason. These awards include cash awards. They are not limited as to number that may be awarded to any one person or group. Is it any wonder that the judge wants to convict you of every crime that the IRS and BATF charges you with? Is it any wonder that all of these people will lie, cheat, steal, do almost anything to destroy you, to seize your property? You see, the more money they recover for the payment of these fraudulent taxes, the more personal reward they are paid. They don't believe this bullshit that IRS agents and judges and all of these other people, U.S. attorneys, don't make much money. It depends upon how well they perform, and if they perform well, they can make a killing. Literally. Over your dead body. They are not limited as to number that may be awarded to any one person or group. There is no limitation placed upon any award. Any person or group of persons can be awarded this money, including U.S. attorneys, United States attorneys, federal judges, your certified public accountant. And you think he won't turn you in because you're paying him to do your taxes? You better think again. They got this set up so anybody will rat on you. Anybody. Your best friend, your mother might. The President of the United States, members of Congress, your mother, H&R Block, etc. The awards may be given to the same person or group each minute, each hour, every day, every week, every month, every year, or not at all. In other words, the government and the alleged Internal Revenue Service, also known as Bureau of Alcohol, Tobacco, and Firearms, have a legal, now that's not lawful, that's legal. There's a big difference between legal and lawful. It's legal, but it's not lawful, system of bribery. The bribery works against the citizens of the several states of the United States of America. We've been betrayed by those we trusted. We've been robbed of our money and property. It happened because we trusted imperfect men to rule imperfect men, and we failed in our duty as watchdog of liberty and freedom. A nation or world of people, ladies and gentlemen, who will not use their intelligence are no better than animals that have no intelligence. Such people are beasts of burden and stakes upon the table by choice and consent. If you can't find a law that requires you to file and pay the income tax, why in God's name are you stealing that money and food and shelter and comfort and security from your family? If you're doing it because you're afraid of the IRS, then you're nothing but a stinking, rotten, miserable coward. And you'll have to look yourself in the mirror every morning, understanding that. Good night, folks. God bless each and every single one of you. Good night, Annie Poon Allison. I love you.